This is a long overdue video about overstayers. I'm going to talk about the immigration rules, how you can make an application if you're an overstayer under the immigration rules, and also if you do not fall within the immigration rules, what you're meant to do if you're an overstayer and you're doing an application outside immigration rules. So first, let's look at the immigration rules. The first thing that I want to look at, and this is, I'm hopefully going to do a few case studies in the following weeks. So you will find a couple of cases that I will deal with on the 20-year basis. But the first point that I want to talk about, the first rule that I want to talk about is 20 years spent in the UK. Now, if you spend 10 years legally in the country, you are able to apply for indefinite leave. That is under the legal status. If you are not legal in the country for the whole 20 years or you've not completed 10 years legally, what happens then? Now, when we talk about the 20-year rule, first thing to understand is 20 years means 20 years. You complete the 20 years. If you have been here all this time and you've made applications, you've been refused, you have got appeals that have been dismissed, and then this is the situation for you that you are still in the country, you still do not have any legal status, and you have completed 20 years, then you fall within the immigration rules and you're able to do an application to apply for legal status in the country. Now, once you've been granted legal status under this rule, you will be given 2.5 years leave on a 10-year route to settlement. So contrary to popular belief that some people have, that once you've completed 20 years, I've actually had some people come to me and say, I've completed 20 years. When can I apply for nationality? Doesn't work like that. Once you complete 20 years, you cannot apply for settlement or nationality. What you apply for is leave to be granted under the rules, which would be 2.5 years on a 10-year route to settlement. So if you've completed 20, you have to complete another 10 years on top to be able to get indefinite leave. Now, I always tell clients once they've completed 20 years and they've been granted legal status, then I say to them, now you can switch to any other category which gets you status indefinite leave in 5 years' time. So that's always worth considering and exploring. So my first advice, if you've completed 20 years, you need to look at what your documentation is. What the Home Office requires is full official documentation to show that you have been here all this period of time. Now, these could be bank statements, could be tax records, could be your doctor's records, could be your insurance documents, could be bills, could be bank statements, whatever it is that you have, which are from official sources. What are official sources? Official sources are those that you cannot change. For example, you go to your landlord and say, give me a tenancy agreement spanning the last 20 years and submit that as your evidence of residence in the UK for 20 years. It will not be acceptable. That will be one part of the evidence, but it will not be accepted as a full evidence of full 20 years. If you have doctor's records, for example, your NHS records over 20 years showing that you have been regularly going and seeing the doctors or getting your medication, and plus you have your bank statements, plus you have your tax documentation, you have bills in your name, that is the perfect kind of 20 years application where you have official documentation covering the whole period. What happens when you don't have official documentation covering the whole period? Then you are able to put in letters of support, you're able to put in other documentation that will help you bridge those gaps where you don't have official documentation. So that's the 20 years thing. And please understand and remember, if you do have gaps of official documentation in your 20 years, it's not the end all. That does not mean that you can't make the application. We routinely do applications where we do not have 20 years worth of official documents. All that then we need to do is we need to make sure that we are particularizing every year. We are covering the gaps with letters of support from friends and family and previous employers or previous landlords or previous or friends that you've lived with. All those kind of things can be put in. Of course, it is case sensitive, fact sensitive. So it will be on a case to case basis that I can make these choices for you. What I understand is that some people have hesitation towards making an application because some lawyer, some friend, some relative has told them something that if you do an application, even after completing 20 years in the UK, you might be refused and removed, or there is a problem why you can't do this application. Please don't just sit down and not do anything. If you have completed 20 years, please submit an application. Or if you have questions about it, speak to somebody who understands it and knows what the law is and has practiced long enough to have experience in these applications. Of course, it goes without saying that if you come to Bukhari Chambers, we are very happy to handle the matter for you, and we've got extensive experience in handling these matters all the way up to the appeals. So that is where you get the benefit of coming to Bukhari Chambers. The second point I want to talk about for overstayers is the fact if you've completed half your life or more than that in the UK. So I get a lot of young people coming to me and saying, well, I came to the UK, I was a child, I overstayed with my parents, and then we were granted leave, and then this happened and that happened. But the fact that they've completed more than half their lives in the UK will allow them to be granted status in the UK on that basis alone. So if somebody is in the country, does not have legal status, but has spent more than half their life in the country and are still under the age of 25, then they can make this application under the immigration rules. Again, they will be granted status on a 10-year route, 2.5 years, and they can continue with that. But there is now a new law which says that if you have completed as a young adult, this is the category that we are now talking about, that if you have completed 5 years after being granted leave under this half-life category and your last leave granted was under the private life route, then you can apply for indefinite leave. So again, fact sensitive, case to case will differ. So if you feel that you fall under this situation, then please do talk to us and we will guide you through it. Third category I want to talk about is when you have a child with you who has spent more than 7 years in the UK and is still under the age of 18. Now, of course, the 7-year rule, a lot of people already know about it, but I will clarify it for you. 7-year rule simply says if a child is born in the UK or has spent 7 years in the UK continuously, they are allowed to apply for status on that basis. So if a child was born in the UK and has completed 7 years, they'll be granted indefinite leave. If a child has completed 7 years, were not born in the UK, then they will be granted leave 2.5 years, and then if they have family members around them, they could get the advantage with that child as well. So if you're an overstayer, you have a child with you, child is still under 18, child has spent more than 7 years in the UK, the whole family can get status, and you don't have to make separate applications for the child and then separate applications for the adults in the family. You can all do this in one go. Again, Bukhari Chambers, very experienced, extensively experienced in these applications, have been doing so for many, many years. Now, one thing that I want to point out here, if a child was born in the UK and has completed 10 years living continuously in the UK, they will be allowed to apply for registration as a British national. So having completed 10 years in the UK since birth, not since coming to the UK, since birth, if you've completed 10 years, then yes, that child can be registered as a British national. And of course, that automatically means that the rest of the family can get status in the UK as well on the basis of family life. The fourth category I want to go into is where you don't fall under any of the first three categories. What happens then? You've completed 15 years, 16 years. You've been here without any family, without any children. You are alone. You have spent all this time, but cannot imagine going back to your country because there is simply nothing for you to go back to. What do you do then? That is when you come under the fourth category, which says that you've not fallen under any of the other categories, but there will be significant difficulties to your integration to your country. Usually the Home Office looks for, you have retained the language and you've retained the religion, or you retain the connection with the culture, and you were born in that country, you spent the first X number of years in your country, and therefore you would have retained the knowledge of your country so you can go back. My arguments always, and the way we argue these cases always is, it is not just that you're going to forget your language if you've been here 15 years, or you're going to forget your culture or your religion. The fact that you have nothing to go back to. You may not have any family, you may not have any assets, you may not have any employment prospects. On top of that, if you have certain relationships going here, you've established yourself in life here, there are circumstances which can be called compassionate or exceptional, then those can be argued under this fourth category. So overstayers who do not fall under the first three categories can make an application in the fourth category. Case to case basis, that is how we decide what to do. Another category that I want to briefly mention here, and I will do a separate video on that, is when you are married. If you're an overstayer and you're married in the UK, if you're married to a European national, well, it doesn't really make any difference anymore, because the European national would either have settled status or pre-settled status. If you're married to a European national, you can apply for leave. If you're married to a British national, you can apply for leave. There are rules, there are laws that say that even if you're an overstayer, if you fulfill certain criteria, you can be granted status. And this brings in the new definition of unmarried partners as well. Remember, previously, the unmarried partners definition used to say that you had to show 2 years of living together or cohabitation in a relationship akin to marriage. That means you're living together as husband and wife. Now, the new definition acknowledges that in today's day and age, there will be scenarios or situations where you may not be physically living together. You may be in different parts of the country, maybe in different locations, sometimes even in different countries, and you can still carry on your relationship. Again, will be fact sensitive, would be based on exactly what your scenario is, and then we will decide how it can or cannot be done. So this is a welcome change in the rules, and the new definition of a partner now can be used and utilized in order to make these applications. I hope this has been helpful. I will be doing further videos, especially on this insurmountable obstacles bit, and then we will talk about it in more detail. Thank you very much for watching.